Hello, everyone, and welcome to this week's episode of IPWatchdog Unleashed. My name is Quinn. Thank you for joining us here today for this conversation. And I have with me my good friend, John White. And I say that, a lot of people in the industry are my good friends, but very few people in the industry or in life have known me longer than John. And that's a function of me teaching the PLR Patent Bar Review course. I started back in 1999, and that famously, a lot of you know that's a course that John initially created and then invited me in to teach with him. And here we are 26 plus years later, almost 27 years I've been doing this. And we've been friends all along. John was my best man at my wedding. We actually live only a couple miles apart now. John, thank you for joining us.
Well, thank you, Gene, and that's true. I've known you in your 20s, 30s, 40s, and now 50s. It doesn't seem possible. We've known each other in 4 decades.
Yeah. And hopefully you'll know me in my 60s, too.
Right. That's the plan, anyway.
That's the plan. Well, and that's why I started really getting serious about losing weight. Got both my hips fixed. The first hip was bad. I got done years ago, was not right, and I've had corrective surgeries, and now I can work out. And working out, eating healthy.
You're going to be renewed.
Yeah. So that's good. So the reason why John is here today wearing a tie, and I'm wearing a tie along with him, is because we are actually in the studio recording the new version of the PLI Patent Bar Review course. And I don't know that there's too awful much to say there about that, but maybe we could start the conversation there and see where's the exam currently in terms of, is it in phase, is it out of phase, how far out of phase is it? Because I think a lot of practitioners might be interested in knowing that, because once upon a time, this exam was more of a history test.
Right, and that has changed over the years. It was a history test in the late 90s and early 2000s, and then with Director Capos, he decided to make the exam more relevant, more current, more relevant to current practice. But it's hard to do, right? Because the MPEP is updated about every 18 months. And in between, you have stuff that's updated for various policy reasons. And for example, during the Capos era, there were a lot of things that tried to make things easier, faster, better. So you had all kinds of things to speed things up through the patent office. They were trying to work on the back file and stuff like that, he and Bob Stoll. So you had current practice as reflected in a version of the MPEP, and you had some interim stuff. But if you went to actual current practice, you were another year ahead of that even. And so the exam tries to be there. And then we entered, during the Capos era as well, AIA. And so the exam in reality became very out of phase simply because so much was happening.
Yeah.
And we've entered another one of those eras where the new director and deputy director are really doing a lot of stuff right away. Mm-hmm. And so the exam is necessarily not current because it's not reflected in the MPEP. Right. And so, it's just the way it is. So we're re-recording everything knowing there's a few things that we have to tell them but isn't yet tested but will be.
At some point, yeah.
At some point. So we're kind of riding that fence right now as
so
we do this.
The one good thing about what the acting director Coke Stewart and now director Squires are doing is it's more aimed at the PTAB. And not to say that that's not important. It's a very important part of the practice. It's very important obviously for patent owners, and increasingly petitioners are starting to feel some of the angst that patent owners have felt for most of the last 12 plus years, right? But that doesn't usually get tested on the exam. I know it's a part of the testable material, they define it and such, but they've never really asked the civil procedure level kind of questions about the PTAB. It's all, how do you start it? What gets included in a petition, and that's statutory. So that part of it's not changing. So the exam kind of is likely not to go down that path too much, right?
No, and in fact, it wasn't until the last cycle or two that the PTAB rules of practice became a part of the testable material. See, that's the irony. The PTAB's ever present, in what we do, as practitioners, but there's no chapter on it in the MPEP.
Right.
And it's not something that examiners engage in. They never practice before the PTAB. There's the occasional ex parte appeal maybe, but so these things have never made it to the exam, and then a few years ago they decided, no, this should be on the exam in some respect. And so they test the basics, which is, as you say, the statutory bases of these things, how it starts, who participates, what happens when it's over, and they kind of frame it there. But they added the rules of practice, the PTAB rules, as a exam eligible thing on the last cycle or two. And so you can expect some questions on it, but they don't drill down like they could.
Right. And that makes absolutely no sense to me. Not that they don't drill down on it, because I don't think that they should. This has always, for me, been a frustrating thing. So for those of you who are in the industry and you took the exam, say, in 2010, 2011, you know that you did not get tested on KSR back then. And what we heard, and we still hear occasionally today from people who, now that level, the person who took the exam back then, likely partner level, if they're still engaged in practice, maybe they're in-house. And we still hear today the people who report to those folks, and they'll say, oh, it's a history test. You don't need to know everything that's current. Just get the old exams and memorize them, because that was what you needed to do in that 3 to 4 or 5 year period.
Not going to work now.
It's not going to work now. Number one. So, but number two, so I like the fact that the exam, as we say, chases the law. It's never going to catch up, because there's always the lag, as you've identified.
Right. There's the lag
with the MPEP. But the frustrating thing for me, and I haven't talked to the folks who are now at the office about this, in charge at the office, I should say. I've talked to many people at the patent office, as you know, over the years, that say, what are you doing? Why are you asking IPR questions? Why are you asking re-examination questions? For God's sake, why are you still have inter partes re-examination as a part of the testable material? These are not things with inter partes re-examination. You can't even do one. You haven't been able to do one since 2011. I mean, not only does that not make any sense, but why not focus on the stuff that a newbie, a patent agent, or a new minted patent attorney is likely to do? And they don't. I mean, because you'd more focus on drafting, you'd more focus on sufficiency, you'd focus a lot more on 112, you'd focus on claim drafting. You wouldn't focus on the exotic stuff, right? It always jumps to my mind, and I just heard this again the other day, if you hear hooves outside your window, it might be a zebra, but it is far more likely to be a horse, right? So why not have this exam be for the far more likely scenario that you as a new practitioner are likely not going to get hired for $1 million piece of work to represent somebody in an IPR?
Well, that's always kind of been an exam feature, and the irony is there's no book that is written and tested for the practitioner. The book that is written is for the examiner, but it's tested as though it's for practitioners.
Right.
And so there's a lot of questions on the exam that don't reflect reality. And so just recently, not so long ago, we had a student report. They had 3 questions on facsimile. Okay. How many people still have a fax machine that don't work at a doctor's office or a pharmacy? I think these are the last places on planet Earth that still have fax machines. And so you have the reality, which is no one's used a fax machine at the patent office for a long, long time, and it's exceedingly rare. And yet the patent office focuses on it because it just happens to be in the MPEP, and it happens to be in their stash of questions.
Well, and it's also an easy question to write, right? Like, which of the following things
cannot be faxed?
Or can be faxed, right?
Yeah.
I mean, it's a very easy question to write. And the fact that it's not relevant in any way, shape, or form to practice doesn't seem to be a limiting feature.
Doesn't seem to be a factor. And so I've just been doing the recordings, and things that happen rarely. I mean, twice in 40 years, I've had a new ground of rejection raised by the board. But in the questions on the exam, 2 out of 3 questions relate to a new rejection being raised by the board.
Yeah.
So it literally never happens, once in 20 years, and yet it happens 2 out of 3 questions on appeal.
Yeah, no, I know, and it's crazy, And they always test the corollary. if there's a corollary to a general rule that makes little or no sense, the likelihood that that's going to be tested is extremely high.
Yeah.
You know, and the one that comes to mind right now is because you went and you edited some of the questions that we do, and you took out a date I needed.
A date I needed.
In one of the questions, and it's because it looks to all the world like you missed the foreign priority, but because that foreign application was withdrawn prior to publication.
That's right. You can reset it.
It resets it, right? So, but the irony about that question, and that I think has appeared on old exams at times, you know, like now really old because we don't get to see the questions they're asking now, but when they were releasing, that was something that would get tested. And that always struck me as if you know the rule, you're more likely to get that one wrong. Because if you don't know the rule, people get that one right, you know, and because they're like, oh, well, I'll just claim priority within 12 months. That's within 12 months. I'm like, no, it's supposed to be 12 months from the first filing, not any filing.
It's Paris Convention, you know, so it goes back to the first filing. It dismisses all those subsequent to that. Yeah, and that's been the rule, you know, and the statute and the treaty, you know, forever. But the exam is what the exam is, and they haven't released any questions since 2003. So more than 20 years we've been operating. You and I know the exam, and by interviewing students that have taken the exam, we know the subject areas that they emphasize, and so we try to anticipate that. But that's all we can inquire about is what questions or what topics did you feel like you needed more preparation for? We have no ability to say, you know, what they ask about, because we can't. And likewise, they can't tell us. But we can ask, what do you think you needed more preparation on? And they'll tell us, well, they seem to be asking a lot of questions about oaths. They seem to be asking a lot of questions about, you know, PCT, fill in the blank, you know, whatever it is. And so we try to anticipate these things, and I think we've done a good job. But without them releasing questions, you know, you can't help but feel like you're kind of flying blind a little bit.
Yeah, I get that. But the one nice thing that I always kind of rely on is whenever we do a major update and add new questions, because there's a big new rules package, and there hasn't been a real big one in a while, not at least that would be considered testable, because it's like the PTAB stuff, as we've said already, they don't usually test very much. But when there is, you can read through the Federal Register notice and you know exactly what they're going to ask.
That's right. For those of you that really have time in your hands, read Federal Register notices. Right.
Well, that's what we do. And so it's always good to hear that, like, after we do that and there's an update, we've had students tell us it was like, we wrote the exam.
Did you write the questions? I know it seems like it, because we understand that the folks in charge of training the examining corps are also charged with coming up with a few exam questions. And the reason for that is the office administers a test, which is about half of our registration exam, to examiners who are heading for partial SIG authority. And so within the office, there's a 50-question exam that is half of what we do. And so who writes those questions? Well, the people that prepare the training.
Right.
And so you and I, by virtue of knowing that, write
those
our questions from the same materials.
I remember that this is now years ago, somebody was arguing with you about a particular question.
Yes.
And it was one that I wrote, and he I think it was he said, but that's not what it says in the MPEP. And it wasn't that the MPEP was we were incorrect, our explanation, based on what was in the MPEP. The MPEP just said it differently. But if you went back and you actually read the Federal Register notice at the time it came out, what we said in the explanation to the answer was exactly correct. Yeah. And so I remember you telling the guy, so you have a choice. You can either trust us or not. Yeah. But that is correct, because these questions, when they got written, they were written based on what was in the Federal Register notice.
And what's funny about that, it adds another layer of funny, is AI, you know, is on everybody's lips and stuff like that, and is at everybody's fingertips. And so when you and I have been lecturing and doing some of our courses, especially over this year, people have pitched us stuff, and we've checked the AI answer. and we know the answer, and we know the MPEP answer. And what's interesting is AI is wrong half the time, but you don't know which half, and you don't know which one. And so students now, it's not necessarily a cheat sheet, but it's a shortcut, they believe. And so they reach for AI all the time. If it's not done automatically just by listening to them babble or something like that, AI is on and presents information. It's astonishing how right and wrong it is, and the reasons it's right and wrong. And so, yeah, Gene and I don't mean to say this in a way that makes it sound like we know it all, but we know the right answer, and most don't. And it's just the way it is.
Well, and I don't know why I did this, but you were, because the way that the course, those people who took the course back in the day, which is like any time prior to COVID, would not really recognize the course as it exists today.
Right. It's quite different. It's now an online enterprise, and Gene and I are only let out of captivity from time to time. It used to be a live enterprise,
like 10 or 11 weeks a year.
Yeah, and Gene and I were ever present, across the country, and then we were cooped up with COVID, and the market has not really responded to a revival of a live in-person format. It's live online, but it's not live in person.
And we have a couple different live online versions. One where we do across 8 days, we do 5 hours across 8 days, the whole thing. And then we do one, which I think is my favorite course, is that we call it the office hours course, which I also refer to it as the Weight Watchers course. So over a span of 10 weeks, you get assignments each week, and you come for 2 hours. We lecture for an hour. We answer questions for an hour to keep you on pace, and that's good. So I forget which one it was, but we were doing one of those in the last 6 months or so.
Yeah, it was over the summer.
And you were talking about plant patents. And I don't know what provokes me to do this, but I went to ChatGPT and I asked ChatGPT, can you file a provisional plant application? And then I went to Google and I asked the same question and went into their AI mode. Google got it right and ChatGPT got it wrong. But ChatGPT, if you had switched the word plant and put in design, I got the answer that was for designs. You can't file a design provisional.
Right.
But you can file a plant provisional.
Yeah, the only thing you can't file as provisional is a design. Anything else is up for grabs, but no designs. And so
just that punctuates your point that you got to be careful with AI, because both were confident. Like they knew for sure that this was the right answer.
The problem with that is, not to, quote and rely on Kim Kardashian, but her complaint after she had taken a run at the California bar a number of times and not been successful, but eventually was how misled she was by these AI things. That
She's a lawyer, Kim Kardashian?
She took and passed the bar exam. I think she studied the law by, the apprentice method,
okay.
And then I don't know that she attended law school. Maybe she did, maybe some online stuff. But anyway, I know she's taken and passed the bar exam because she announced it. This was heralded. But the interesting thing about her characterization of it was, I wish I'd avoided AI because I was getting stuff wrong because of AI. And it hallucinates. And the thing that I was noticing this year was how often a student would send me a question and send me an MPEP section that didn't exist. But it was there. It had an MPEP reference number, and it purported to be the basis of the student challenging me for the answer to this question. And I would go looking for this in the MPEP and discover it didn't exist. So it hallucinates, period, including MPEP citations.
Well, it's interesting you say it, because I right before we started recording this episode, we did a webinar. And the webinar we did was on prompting, AI prompting.
Okay.
And it was, and I think, and I've said this a number of times, I think attorneys who are using the specialized AI tools that don't get out of it what you think you should, and you don't think it's good enough to even use. If you think AI is not as good as a patent agent or a first-year associate, then you're not using it properly. because it's at least that good, at least, and I think it's better. And so I think the problem that you have is with prompting. So I think we're going to probably try and do a lot more with the prompting to get it to deliver what you actually want it to deliver. Because I think AI is stupid, for lack of a better way of saying it. It's like the encyclopedia set, when your parents, door-to-door salesman came when that was a thing and they were selling Britannica and you bought Britannica encyclopedias. It's stupid. It sits there on the shelf. It's got all kinds of answers, but you got to go looking for it, and you got to be able to pull it out of it, right? And I think AI is very similar. The better you are at pulling it out, the more you think it's useful. Now, long introduction to the point was this: during the webinar, somebody asked, and I didn't know how to respond, so I didn't. I thought this webinar was going to be in part about how to identify hallucinations, and
that's the problem.
That's the problem, right? Because the answer is nobody can tell you how to identify hallucinations. And I didn't want to raise it and make fun of the person who asked that, because I think when you're asking that question, you're just not familiar with AI, because AI is very good at lying to you, and it lies to you with such confidence.
Conviction.
Yeah. And if you are not willing to verify what it tells you, or you're enough of a subject matter expert, to whether it be in the technology or that area of law or what have you, to know that it is just giving you garbage, then it's an uphill battle. So I mean, I do think it gets you much further down the road than a first year, second year associate out of law school. But you have to verify. You have to know when it's gotten something wrong, or otherwise. And this came up during the webinar too. Somebody says you can't use one of the other panelists, and I told him I was going to steal it. I didn't know I was going to steal it this quickly, but you can't use AI like it's a magic button. It's not a button to press and presto changeo, you wind up having an application or an office action response. You got to tell it what you need it to do. You got to give it the information and tell it what to consider. You got to tell it what viewpoint and context. The more context you give it, the better. And you got to be an expert in the area, because you're not going to know if it's hallucinating.
And that is really problematic with respect to a book like the MPEP, to draw it back to, the topic that kicked us off, which is, where's the exam and how AI might help. And the reason is I read recently, or heard it reported, that to contaminate a database, that a large language model is learning from, doesn't require that many pages. Somebody said, some certain page count depending on how much, and that can corrupt the answers that it's going to generate. And I thought to myself, well, that's interesting, because the MPEP is a flawed document in that every time they update it as best they can, as much as they can, but at some point they've got to call time, because they need to push a new edition out the door. And they'll tell you right up front, and I've been looking at this for years, the pages up front will tell you these topics have been updated here, but where they appear in other chapters, they haven't been. Mm-hmm. All right, so that means an AI is looking at the MPEP for the correct answer, and will find it, but also find 3 wrong answers. And so then AI has to resolve, well, there's 3 wrong answers here, there's 1 right answer. I'm going to go with the wrong answers because there's more of them. Right. But they're wrong, see?
Yeah.
And it doesn't know that, and neither do students. And so they will say, but the MPEP says this. Well, indeed it does, but look over here.
Right.
Oh. Yeah, you see, and so that's the problem. And I didn't realize how little corruption could make for unreliability. So your AI is entirely dependent on what you're training it with. And so I think if it's well defined, if you're within Ford Motor Company and you only look at repair manuals generated by Ford Motor Company, you're probably going to get a pretty good answer on this filter where, that gasket where, this torque here, that spacing, that adjustment over there. But if you're looking at the internet of people who work on Fords, Well, a lot of people don't know what they're doing.
No.
And that will really contaminate those who do. And I've noticed this recently as I go looking for stuff, and now whenever I go looking for stuff on whatever browser I'm using, they generate an AI answer. It's interesting because like what's the oil capacity of a particular motor in a particular car? It'll tell you, but I didn't tell it which motor. Was it the larger or smaller? Because sometimes there's a difference, And so they'll just give you a number, and I think that's interesting because it can't know that for sure. But it says it like it does.
Right.
Is that the 6-cylinder motor or the 8-cylinder? It's
right.
Stuff like that makes a difference.
Well, and I've got a lot of examples too because I've started using it a bit more for a variety of different reasons, and sometimes it's good, sometimes it's not good. But you got to have a filter yourself. So, as you know, I went to take my truck to get a tune-up.
Yes,
and
indeed you did.
Got a absolute ridiculous quote.
Yes.
For just the spark plugs were going to cost me more from this place than the entire tune-up should have cost, including labor, right? So I'm like, okay, well, I'm not going to leave.
I'm on Gene's phone a friend for truck repair.
So I'm like, okay, did I miss something? This is right. So then I went to ChatGPT and I was asking it, for how much should it cost, and different areas and so forth. And we live about as far north in Virginia as you could actually be and still be in Virginia, which means that Maryland, so the major metropolitan center for us is no further away in Virginia than it is in Maryland. Is a little further away in West Virginia, right? So I thought, well, if I could go over to West Virginia, go to an independent shop in West Virginia, maybe I'll pay a few $100s less. I could take my laptop, and save some money. So I started looking well, where is it? And ChatGPT told me it was going to be more expensive in West Virginia, the middle of nowhere, West Virginia, because their hourly rates were higher than they were in Northern Virginia. And I said, well, that can't be. That just can't be possible. You just told me previously to this chain that the further I got from DC, the cheaper it would be, which makes sense, right? And they said, yes, that's correct. It would be cheaper in this. So it instantly caved on itself, and flipped. And it's like, there's a problem here with some of this. And I tend to think that going down this path, not talking about the specific, because I do think that people are doing some really creative things in the specific verticals that we know about in the patent space. But I think the difference is the training materials, and then also what you give them for source materials on top. So it's all these models have been trained on patent-heavy stuff, which is a different level of sophistication. And then you can tell it, and here are the source materials I want you to use as exemplars when you're doing whatever this task is. So, and you can give that to ChatGPT, some of the source materials, but it's a general AI. And these general AIs, I think, are just not created the same. I mean, how could they be? For example, a couple of years now, it's maybe 18 months ago, Google licensed Reddit data for training. It's I thought to myself, if this were an AI I was creating, Reddit would be the last thing I'd want to feed it.
Yeah, I mean, that's, and this, to spin it back to patent bar, Reddit has a fairly active community that talks about the patent bar, and the folks at PLI monitor that, plus other bulletin board style things out there, people are discussing stuff. And inevitably what you get dominating these bulletin boards and discussions are people who breathlessly don't know what they're talking about because they've failed many times on the exam, something like that. And by golly, they've taken our course 5 times and they still haven't succeeded. So they're critiquing the exam, they're critiquing our course and all this sort of thing. And the people you don't hear from are the ones who are one and done. You see, they have no need for this resource to unscrew everything they've learned from it. Whereas if you start looking at these sorts of things and taking it seriously simply because that's what's out there as a resource, you will be hopelessly misled.
Right.
It's like learning how to change a tire from people who've never actually pulled it off. Well, is that going to help you?
No.
No.
In Reddit,
no,
the thing that
don't do it. Stop.
Yeah. The thing that always interests me about Reddit is like the first answer is, that is the dumbest question I've ever heard. The second answer is, well, you can't do what you're asking. And then the third answer is usually some variety, and sometimes they're in different orders, but then there's some variety of, you shouldn't want to do that. What you should want to do is the following. It's like, okay, well, yeah, I should want to tune up a Ferrari, but I don't own a Ferrari. I own a Ford.
Yeah.
I mean, it's not helpful. So much of the stuff on Reddit. So I tend to think that the general AI systems that are out there are really not trying, and I still don't think they're trying. They're coded to give you the right answer. What they're coded still
answer.
Yeah. They're still working on what's the next word, what's the likely next word. And they're large language models, calling them AI. If they're smart accidentally or incidentally.
Well, I read your question there a few moments ago is, I wanted to learn how to identify hallucinations. And so the problem that you see recurring for lawyers is they get AI to help write a brief, write a response, something like that, and they hallucinate the cases. So this lawyer thought, I got it figured out. I will prepare this using AI, and then I will use a couple of AIs to check every case.
It's funny. So you just read that article.
Yeah.
Yeah, okay. I was going to mention that.
And they still got it wrong, and the guy still got sanctioned, and, everything went badly. And I thought, that, because you said, hey, AI is at least as good as a first-year associate or something like that. Well, I can tell you a first-year associate wouldn't screw up that kind of assignment. Tell me if these 5 cases exist.
Yeah.
They could answer that question, whereas AI couldn't check.
Right.
And it was a different AI.
So, but was it what was unclear to me is whether or not that was like a general purpose AI that was being asked to do this, or whether it was, because I don't know in our space any AI, maybe there are people working on the tools and I just haven't seen it yet, where you can get like one of the patent companies, the companies that cater to patent attorneys, to write you a patent brief, with all the cases and everything. So what I think it probably is people are using these general AI tools to do this. And that, I think, is where you get into a lot of real problems with and you've got to check the citations. Does this case actually even exist? That's the first question. And then the other thing, like in our space with the MPEP, how many old versions of the MPEP are still online? Like
all of them.
Every one of them. All the way back to the 1920s, right? And every revision since then, there's many dozens, probably 100 or more editions of the MPEP online.
I would say.
And one of the other things too is, like, you look at some of the really old questions that were released in the 80s and 90s. Those questions are still in many cases relevant today, except for the right answer is now wrong and the wrong answer is now right.
Yeah, they've changed that dramatically. And so that, even the most recently released now is more than 20 years old. So things have changed dramatically since then. And so if you don't know what changed, you honestly, and these are the resources that the Patent Office points you to the uninitiated to go get ready for this exam. They say, well, here's some released questions. Well, that is playing with fire, because by now, many of them are wrong, and the problem is, what is the margin of passing? It's 1 or 2 questions, and so it doesn't take much to lead you astray, to experience the Kardashian moment, which is, gee, I wish I hadn't relied on this because I got so much wrong, So it makes for interesting times where we are right now.
It is. So maybe we could pivot just a little bit, but stick with maybe the same theme of rules and regulations and MPEP and that sort of thing. As you were going through and updating the course this last time, was there anything in this that any changes that would particularly apply, do you think, to current practitioners? People are doing in practice now. And the reason I ask it like this is because in my experience, well, I'll tell you a little story. So when I was a new associate at a law firm, I figured this out pretty early on. You would get an assignment from the partner. I need you to do the following, and there's a recent case on X, Y, and Z. And I would go, and I could never find the recent case on X, Y, and Z that the partner was referring to. And then one day I happened to find that, and that case was 15 years old.
So recent.
And so from that point, then I started applying the knowledge. Okay, when a partner says recent case, what that means is I need to know when did they graduate law school and when were they last a research associate, like a 1, 2, 3 years out where you were the one doing the research and maybe the first draft. Because whatever that time frame was when they said recent case is because it's probably the last case that they read fully, in a research mode, right? And that without fail worked. So I had attorneys that were attorneys for 10 years that worked with them. I had attorneys that were attorneys for 10, 20, 30 years. Find out when they graduated law school, and it will be within 3 or 4 years of that date is when the recent case was, right? So
that's pretty funny.
And I then have always applied that even in our space. So sometimes at IP Watchdog, what we'll do is we'll write what I would call a tutorial. One of the better ones that come to mind here immediately was I wrote a tutorial on means plus function. Just like it was in a fairly recent case, but then I went like, okay, well, let's refresh our recollection on what this is, what the rules are, and I did a really deep dive. But it was not like insightful in that it was the law changed or anything. I was just putting it all together into one location, and I got so many compliments from practicing attorneys saying, oh, there was some stuff I forgot or some stuff good to be refreshed every once in a while. So it does occur to me that when you're a partner level person and you put your head down and you're trying to get work, you're trying to do the work, that you don't always stay up to date with the latest changes. That's a polite way to probably say it. Yeah. So what are the latest changes that you think that partner level practitioners should make sure they know about?
There's a couple areas that have changed dramatically. It makes no difference for the exam necessarily, but the petition to make special area. This has been a Pandora's box for as long as it's been around, because it's the one place at the patent office where it can be subject to more or less instant change, and it's pretty political in that whatever the theme of the day is. For a while it was superconductors, then it was combating terrorism, then it was all the green pilots. Are you going to save energy? Are you going to do this? Going to do that? And so these things are not captured in the MPEP. This is the irony. You got to go to the patent office website and look over really the last 6 months of press releases to find out the things that matter to practitioners, because they'll think that something is still in place because it was a pilot program 5 years ago. It's gone. That was the last administration, and the political winds changed, or the things that they wanted to focus on. And so now it's another list of things. And so they may confidently represent to a client, I can get you to the head of the line because you're a small business and this relates to saving energy. Oh, no, I can't. I can, because this cures cancer or treat. No, I can't.
Yeah, for that plus $4,000, like you get you to the front of the line, right?
Yeah. And so there's all these things that you may represent, and you'd be wrong, because the pilot programs, which are those that are steered by political whims, and I'm not going to say these whims good or bad or indifferent. You and I happen to know over the arc of the time we watch it, these things make very little difference, right. But they sound good. Right. We support green energy. That's completely ill-defined. We support medicine, whatever. We support the future.
And the funny thing is, and I'm sure this director will have his own things like this, so allow me to make fun of it before he announces one. Because the thing is it doesn't, they don't matter. And they get so excited buy, like patents for humanity.
Well, no, I mean,
what is a patent for humanity? And what does that mean?
Here's one that's meaningless, but you and I know it received a lot of press and a lot of pomp, was the creation of a new registration category for those who will just practice in the design area. And you and I know this was talked about at length at the highest levels in the PTO, something I'm very proud of. I pushed it out and all that. And as far as I know, no one has taken advantage of it in the years that it's been put out there. I've written about it. I've pushed it. I think it's a great idea, kind of a thing, in that it opens up an area of practice for people with unique perspectives and expertise and all that sort of thing. And there are some firms, but only about 5 of them, that could probably use these practitioners. But this is totally out of proportion to the way it was pushed and advertised.
And it's not nobody. I think there's been one person who's bad, because then
it's
question.
A handful.
It's a very small handful, and in that, because I had I won't say who, but I had you were in on this pool a little bit too.
Yeah.
And you had, what'd you say, like several hundred people?
Yeah.
Or
I was in the hundreds.
I think you were at 300, and I said, well, that's not the number it's going to be. And then I was talking to somebody who will remain nameless, but and he said, well, I want in on that pool. And I said, well, what's your number? I'll let you go first. And he said 4. And I looked at him and I'm like, that was what I was going to say. So now I've got to decide, do I want to go 3 or do I want to go 5?
Yeah.
And I decided to go 5 because I thought 3 was just, it's got to be more than 3.
Yeah, got to be, yeah.
And it wasn't. It was lower. It was lower than 4. And I don't know where we're at now, so this is somewhat dated, but it had been in existence for many, many months, 6 or 8 months when we were looking at this. And my recollection is that there had only been one person who qualified under that, who actually had at that point in time passed the exam. Because you still have to pass the exam.
Yeah, you take the same exam, but your practice area is limited. And this is not to say this isn't a good and worthy thing to pursue. It's, what are your career prospects? And simply because everybody else can do everything, right, you can work in a certain area.
I will go as far as to say this is not a good move. Don't do it. I think it's because we both know, and as a function of having done this for you probably 35 plus years, me almost, it'll be 27 years at the beginning of next year. We know many people who have had very good careers, partner level, in-house people who did not have enough credits, went to community college to take physics or biology,
fill in the blank,
whatever it was. Physics is the easiest one because it's the fewest number of courses you need. So that's why it usually winds up being physics when you're doing this. So they go and they get, I think it's 24 credit hours of physics.
24 credit hours in physics.
You may, since you have a degree, since you're already, many of them an attorney, or the people who are going to go be agents, a lot of them have advanced degrees. They just have the degree in a different name or with a different focus. So you'd probably have a handful of physics credits already that would suffice. So you take a couple more physics credits, then you take the exam. Now you can do everything. And as long as you knew going in what you were getting into, because you got the people who do that often, they're computer science people, so they're very technically sophisticated. They can handle an awful lot of work that exists in the software era and the AI era, but
Absolutely.
They don't check the box to be able to just walk in and put their degree down and take the exam. So for those people, it makes a lot of sense to take the extra credits and then be able to do it all. So I would encourage people, don't take the design-only exam. Go get 24 hours of physics. Even if you need all 24, go to community college, because they don't care where it is. It's just got to count for physics majors.
Yeah, it's got to count toward a degree in a STEM topic, physics or otherwise. But I would agree with you, but the whole premise of this opening up was to make this less exclusive. And so that's what I mean about things not aligning with reality. the Patent Office does this from time to time, and so this will be disclosed with great fanfare. And so I hope the Patent Office does things that will make a difference, as opposed to things that sound good as a public relations kind of thing. I want the system to work better. I want valid patents issued, that sort of thing. And if AI, we've been talking about AI, if AI can be employed as a tool to help make that happen, great.
Right.
And likewise, better examination. So, the examiners are more scrupulous, about how they go about making rejections, and likewise, the prior art they have is better. It simply is going to result in a patent that's much, much less likely to fall when challenged. So.
Well, right. And at some point in time, I think we need to, as AI gets better and better, and searching is something AI does really pretty good right now, because if you give it a closed universe, and it can be a giant closed universe, but if you give it a closed universe, telling you what's in that universe or a subset of that universe, it's very good at summarizing.
Yeah, it does a good job of that.
Very good at telling you what's there, very good at telling you what's not there as well. And I think what needs to happen, and we're probably not there yet, but we're probably closer than a lot of people think, is have a high quality AI search and then examine based on that. And then we could almost do away with the PTAB, or almost do away with most validity challenges. Because the question in the best validity challenge is, oh, here's a piece of prior art that the examiner didn't know about, that you didn't find, they didn't find, and it's your invention. Exactly. Well, over time, when we were younger, both of us, we knew attorneys, litigators that made a name for themselves. If it can be found anywhere in the world, we're going to find it, right? And it's not cheap, but it's getting very, very cheap now with AI. And if AI couldn't find it, if you have your arms around a big, huge corpus of scientific data and AI can't find it, then are we really going to, a couple years later or 10 years later, when this starts to really become valuable, go and say, oh, well, we got to take that patent away from you because of this late arriving thing?
The likelihood of that should go down, right?
It should.
It should.
It should just go down, but it probably, it could go down so far to say, okay, well, we don't need to do that anymore.
Or there's such a presumption in favor of it standing up that the challenge is very hard to pull off.
Are you suggesting almost like a presumption in the statute that a patent that's issued is valid?
Yes.
That's crazy, John.
Gee, Gene, and the clear and convincing standard to turn it back. Golly, who would have thought of that?
Oh, that's a brilliant idea.
Yeah,
I wish I had thought of that.
I know. Implement the law as written.
Right.
Yeah.
Right. Yeah. We got sideways here, and it's not good. It's not bad. It just is. When all the way back when State Street gets decided, and now you can patent business methods. Well, what most examiners use for search, whether they should or they shouldn't, they just did, were issued patents and patent applications. Well, guess what? Nobody had been filing business method patents since the 20s, right? There were the teens. There was that one case that says you can't do it. Nobody did it. So there's a complete lack of prior art in the areas where examiners are looking. So a lot of things in the late 1990s, early 2000s got issued that were not high quality, right? And it's not bad. Todd Dickinson always used to get upset when I would say this, because that was when he was director. Yeah. I'm not blaming you, Todd. I'm just saying that it's true.
But you were there when it happened.
Right. But it was not his fault. I'll defend Todd.
Yeah, I know.
God rest his soul.
But you were there, Todd.
I still miss Todd. I can't believe, and the older I get, I'm saying that about more and more people. It's just like, you can't believe some of the giants from our industry that I grew up.
Have moved on, I know.
Yeah.
To the great, appeals court in the sky.
Yeah, and I hope not to see them anytime soon.
Yeah, right.
But, so we've been talking, we probably need to think about wrapping this up here. We've covered an awful lot of ground here today, but is there a message you want to leave people with, whether it be with respect to AI, with respect to the MPEP, with respect to the patent bar, with respect to don't take the design bar, whatever it may be. What's your final thought, John?
I think be aware of what AI gives you, because you got to be smart enough to recognize the holes in it. And if you can't do that, you have to find somebody who can. You know, that's really, because people think, oh, well, AI put this together, this is wonderful. And in my experience, you got to have the ability to assess whether that was really done properly, and that's tough unless you know the area very well.
Yeah, I can't disagree with that. I think AI is a wonderful tool.
It's a tool,
but it can convince you that it is infallible, and not that it's doing anything to do that, but the way it presents the answers, it just seems so authoritative. And it's right an awful lot. It's
correct.
wrong plenty. And it's. I think the thing that I would leave people with, AI is not a calculator. You know, if you put in 8 times 8 and it doesn't say 64 in the calculator, it's probably because you mistyped, you didn't, fat fingers, or you didn't hit multiply, maybe you hit divide or whatever, and you do it again, and because 8 times 8 with the calculator is always going to be 64, right? 8 times 8 may not always be 64 with AI, and I know that's an exaggeration because it's not that bad. AI is good. It's intended to be an example, but I've had situations where I ask it one day, get one answer, ask it another day, get a different answer.
Oh my!
And in part, I think it's because these models keep getting better and better and better. They're changing, they're learning more. And new releases come out and things like that. So I don't know that it's that maybe quite as whimsical as I may have just seemed to suggest. But I do think it changes if it evolves over time.
No, it does. It does. You're right.
Takes us on a different. So we'll have to be continued
on our next discussion.
On our next discussion. Thanks for being here, John. I
appreciate absolutely. It. I'm glad, and hey out there, everybody, and I will see you soon.